I think, as we've already heard from the keynote, we've got some really interesting stuff to discuss. And when I sort of first heard from Caroline that this event was taking place, what sort of sprang to mind for me immediately was something we've been doing in the law school. I think some of my other colleagues will be talking on similar topics, which is around our new LLB degree and the new modules that we're producing. And the module I've been most heavily involved in is the new contract law module, which I authored quite a lot of, and also took on during production the module team chair role, which basically means sort of being ultimately responsible for the academic side of the module. And I thought the contract law module was an interesting example on these topics that we're looking at today, both in terms of legal history defined sort of very broadly, and more specifically on the idea of sort of decolonizing and liberating the curriculum, because those are elements that we really try to build in to our contract law module. And I think it was something which, when it was first sort of decided, and this was by no means just me, it was other colleagues on the module, particularly Kim Barker, who was module chair before me, and indeed the whole module team. At first we got some sort of, when I say pushback, I don't mean sort of institutional, but we had people sort of raise an eyebrow at the idea of trying to take a more sort of historically, socially, culturally aware approach to an area of law that I think has, rightly or wrongly, got something of a reputation of being quite staid and to some extent sort of unchanging. So sort of to sort of summarize and perhaps to some extent characterize some of the comments, and these are not necessarily things that were said by one individual person, more a sort of summary of things I've heard in my time developing contract law materials and syllabuses. The idea that, well, is contract law really the place to bring this into the curriculum? Because there's an idea that contract law is, as I said, somewhat unchanging. It's not a dynamic area in the same way that something like criminal law or public law could arguably be seen to be, you know, much more dynamic in terms of, realistically, a contract lawyer from the 17th, 18th century would probably recognize large parts of our contract law in a way that the public lawyer from that period would not. There's the argument that contract law, and I think students very much often have this idea that contract law is all about commerce, it's all about business. It's not about society and culture. Students, I think, often think, in comparison again with something like criminal law. And I think, you know, students sort of say, oh, well, we talk about things like racial bias in criminal law. We talk about things like the development of human rights in international law. We don't do that in contract. Contract's just all about agreements and businesses making money. Something else I think we got, and certainly this was something we had to deal with when it came to sort of critical readers and external assessors of the module, that people said, okay, you know, we understand why you might want to take a more sort of broader and less traditional approach to contract law, but how are you going to deal with the fact that at heart contract law is a common law subject? It's a subject which has large amounts of case law that students are expected to know. And I think as well, some people sort of said, well, contract law, the legal history of contract law is sort of already there. Every contract law course basically covers history because it says, well, there was this dark age of contract law when we didn't have nice rules and principles. Then the Industrial Revolution came along and the Victorians came along and they gave us this golden age of contract law where all the rules were drawn up and established. And since then, we've just been sort of refining and perfecting the law by adding a bit of flexibility and a bit of fairness in certain areas. And I think, you know, that is the way often contract law is taught, this sort of Whiggish view of history, that there is a nice progression through the centuries from where we were to this ideal law that we have reached now. And I think what we tried to do with our module was challenge that. So I think we said, you know, contract law, yes, contract law has probably in some ways more history to it, and in some ways is less dynamic, in that large parts of the contract law syllabus do date back a long way. But that doesn't mean that contract law has nothing to say or can't be used as a vehicle to say things about wider issues, and as a way of liberating the curriculum. And in fact, the fact that contract law is so historic is actually a strength in that sense, because it means that there are already major historical events or processes which reflect on contract law, and contract law reflects, which we can then come on to in a moment in the presentation, but which we can then pull out when we look at the case law. I think, you know, it's also probably wrong to say contract law is purely commercial in the sense of thinking of it as simply a matter of economics and a matter of numbers on a balance sheet. You know, contract law is English and Welsh contract law in particular is deeply tied in with how our economic system has developed, and how we have moved from a more feudal system to a more capitalist modern system. Obviously, contract law played a large part in that. A lot of how contract law developed was alongside that, but that is still obviously something that is historic, and that has major, I suppose, importance beyond the purely economic realm. That this is still history. This is still something that's changed society, culture, and obviously in particular has strong links around colonialism and post-colonialism. Again, we tried to make the fact that contract law is case-based a strength. We tried to say, well, we can both teach the case law and look at the wider context. It doesn't have to be an either or. It doesn't have to be, well, either we can give you a lecture or a set of materials which are just case principle in a sort of very traditional way, or we can talk about context and we can talk about society at the expense of any law. There is no reason why we can't say this is what the law is, these are the legal principles, and here is the context in which they were developed, and this is why they might have developed in the way that they did. And I think ultimately what we wanted to do was challenge this sort of accepted narrative that this is how contract law, not just that I think the accepted narrative is not just this is how contract law came to be, but it's sort of this idea that contract law was inevitable, and that it, as I say, has been this sort of march of progress through time to creating a better and better law. And I think what we wanted to do was ask students to challenge that, not necessarily to disagree with it, but to think critically about it, and to form their own sort of opinions on what contract law's role in society has been and what it should be going forwards. So what I wanted to just focus on briefly in this presentation was how we did that. And what we basically did was try and do it at two different levels. So we tried to design in at the sort of macro level, at the level of the module, an emphasis on history, and in particular history as it related to colonialism. So what that most notably meant was including a set of units. So on our module, we have students study 12 units to make up the module, each unit roughly equating to a sort of a week in the course. Obviously, the course does last for more than 12 weeks, but 12 units, each one sort of being its own distinct block. And what we offered was 2 units toward the end of the module. Once students had got the basics, once they'd got the foundations, which focused specifically on comparative contract law. One of those units looking at Canada, which obviously has a mixed sort of system of law. There are influences from the common law, obviously, because of the colonial history of Canada. And then also Canada adds in the sort of interest of the civil system coming from the French legal tradition. And the other unit also looking at law in another country that was formerly a colony, and that was looking at law in Ghana and looking particularly at Ghanaian consumer law. So what we tried to do there was very much take this high level approach of saying, okay, there are going to be certain units where students are directly going to study how history, how colonial history in particular, has influenced the law in different countries, and use that as the starting point for some comparative law, to which students are probably at this stage, second year of the degree, still going to be quite new. Although I think also they were doing some in the other second year module, the public law module, as a sort of starting point to get them to start looking at, okay, this isn't just the law. There isn't just a contract law as it exists in England and Wales, and that's what everybody around the world considers contract law. There are different ways of dealing with the same problems. And this was written into the sort of mission statement, the specification for the module, and I've included an extract there, which really helped us sort of have the foundation, and to be able to say, you know, this has been approved by our various processes, internal and external. We are able to dedicate a chunk of our module to this. What we also tried to do, though, was design in at the more specific level. So I've called this the micro level, which means within every unit of the module, including elements to explain the context and the historical context. So I've just picked out 3 examples from different units. There are many more, but 3 examples where we tried to specifically tie the black letter law, the case law, that, you know, traditionally maybe in a textbook you'd get 2 sentences on the principle of the case, maybe you know, a lot on what a judge said, but very little on the wider context, and where we tried to bring that context in and use history as a tool to engage the students. So we had Gregson and Gilbert, which was a case involving the so-called Zong massacre, where the captain and crew of a ship transporting enslaved persons essentially threw many of those persons overboard, to all intents and purposes murdered them. A case which, in the specific context of the module, we were using to discuss the idea of who the law recognizes as having personhood, and obviously the idea that contract law has both recognized non-humans as persons, most notably corporate entities, and yet at the same time has a pretty shameful history of recognizing humans as mere chattels, and as property which is capable of being owned. So that was sort of a very confronting example. It comes only in the second unit, the idea being that it would really give students a flavour of what kind of thing we're looking at and how we would approach it. To take a slightly different example, later on as we go into consideration, looking at the very famous case of Stilk and Myrick, we decided there to look at the context of the Napoleonic Wars and the policy reasons, which I don't think are often really considered in great depth. I think often people say, oh, there was policy there, and they don't really explain to students what policy there was. Instead, we had a custom-made animation explaining why it was so important to Britain at the time to avoid a precedent by which sailors could arguably hold captains to ransom at a time when obviously Britain and her global possessions were incredibly reliant on naval power. Similarly, Raffles and Wychell House, a case which is normally dealt with very quickly. It's a case on mistake where two people are trying to buy cotton, trying to contract for the sale of cotton coming from India to England, and they get confused because there are two different ships with the same name, both bringing different loads of cotton. Again, what we did there was we took that case and we really tried to extrapolate out into wider history, and we looked at what the context was. Why was it so important that the cotton arrived at one time or another? Well, it was because we were in the middle of the this was during the middle of the US Civil War, obviously a war which was fought largely around slavery, which was being used to support the cotton industry in the southern United States. And the fact that that war was taking place was the reason for these wild swings in the price of cotton. So again, a case which in and of itself is normally used as sort of a footnote. We decided to pull that out and give students much more of an idea of why this mattered and why contract law got involved. So we talked quite a lot about history and the law. We also tried to include some history of the law. So an example here briefly of how we did that in one of the units, Unit 8, where we asked students to look at a Victorian case which used some very famous language about poor and ignorant persons and how they could perhaps need protection from the court. And we then asked students to do quite a lot themselves in terms of thinking about what that meant for law and society, and then using that as a jumping off point for further learning, thinking about how jurisprudence has developed and how thinkers like John Rawls have developed theories around justice and law in more recent decades. So what did we conclude? Well, the module is only just being presented for the first time as we speak, so I can't rely on how students have responded in any meaningful way, because they're yet to have any sort of official surveys or anything about the module. Our external assessor, Dr. Ruth Atkins of Swansea University, was very complimentary in this respect, talking about how the historical and decolonial elements of the module have really helped with the sort of equality and diversity expectations which the OU rightly demands of new modules. I think probably the three things I would say, the three lessons we learned from doing this, were that you need to commit to an approach like this early on in the process. It makes a lot more sense, and this perhaps goes back a little bit to what was said in that fascinating keynote we've had earlier, that this can't be just an add-on. This can't be something where you sort of say, okay, well, you know, to use that example from earlier, well, we'll change all references to Annie in the problem question to Ali, and that has made our module more liberated. It obviously that is at worst sort of tokenism, and even at best it doesn't give that depth. Whereas I think, you know, by the fact we wrote this into our units, our module specification, we literally sort of bound ourselves to do this from the beginning. And similarly, I think it needs to be a wholehearted commitment. I think we sort of talked about what was the right approach? Was it a little bit in each unit, which is what we did, or was it a case of putting it all in one part of the module? And we tried to do both, really, that we had that specific 2 modules at the end, focusing on comparative contract law and colonial contract law, or colonial influence on contract law. But we didn't leave it till then. We didn't say you can ignore this for 90% of the module and then we're going to ask you to care about it for one assessment. The idea was to build it in throughout. And I think it also requires committing to a voice. Something we were a bit concerned about early on was, if we take this approach, are we going to leave ourselves open to essentially being criticised for being biased, for being too subjective, for giving students our own narrative rather than the sort of objective legal education we'd expect. And I think what we did to avoid that was to say, well, we didn't overcommit to a single narrative. The narrative was not contract law is this. What we really tried to commit to was saying contract law isn't necessarily this single procession, and the one way that contract law has dealt with things is not necessarily the right way or the only way or the best way. But we stopped short, certainly, of saying, and the better way is this, or this case was wrong because. That was very much left to things like reflection points and activities where we would say, okay, you know, this is what the law did in this instance. This is why the law was doing it. These were the wider societal factors in play, and then asking students to think about whether they thought the right decision was made or whether they thought these principles should remain valid in the modern day. And I also would say that the other lessons were what not to do, not to overcommit at the expense of law. Some of our early drafts, I think, did stray too far from some of the basic principles, and we got some very useful feedback that, you know, we were to some extent asking students to run before they could walk. And I think that's something that's often a danger when you try and innovate in core modules. And also not to commit on areas we didn't have expertise. There were areas where within the team we didn't have the depth of knowledge, and we at times needed to go out and find somebody else. So, for example, we had quite a lot in one module looking at financial exclusion and how contract law might contribute to that, particularly thinking about e-contracting and financial and digital exclusion. And that was something where we needed to go out and find an author who had the depth of knowledge required, because we didn't have that within the team. And I think